Ohio DUI driving privileges.
If you have been cited for an OVI and either tested over the legal limit or refused to take the test, then the police officer should have kept your license because it will have been suspended by the Bureau of Motor Vehicles. This is called an administrative license suspension, or ALS. While a good attorney will challenge the administrative license suspension, unless it is thrown out, the suspension will start with what is called a hard suspension. During the hard suspension, the court will not grant any driving privileges. The length of the hard suspension varies depending on whether you have had prior OVIs and whether you refuse to take the test. For example, for a first-time OVI, the hard suspension is 15 days if you tested over the limit or 30 days if you refuse to take the test. If it is a second OVI in 6 years, the hard suspension is 45 days for testing over the limit or 90 days for refusing. If the ALS does not get thrown out, an experienced DUI attorney may ask the court to stay the suspension. This would put it on hold while the case is resolved. Some courts are more willing to grant a stay than others, and some will grant a stay but impose their own suspension to allow driving privileges before the hard suspension would allow them. You will not automatically receive driving privileges at the end of the hard suspension because a motion will need to be filed first, and the judge has wide discretion with regard to whether and when to issue the privileges. Courts also require proof of insurance, and most require verifications of why you need privileges, such as a letter from your employer. There are limitations regarding privileges. For example, courts cannot give privileges to do commercial driving that requires a CDL. While each court offers a different level of flexibility with privileges, privileges are typically only granted for occupational, educational, vocational, or medical purposes, taking the driver's or commercial driver's license examination, or attending court-ordered treatment. A court may also order restricted DUI license plates or an interlock system that requires a breath test before you can start your vehicle. The nuances and complexities of dealing with suspensions is yet another reason that no one should attempt to represent themselves or have an attorney that lacks DUI experience. Our clients know that we challenge their suspensions and work to get their privileges as soon as possible and with as few restrictions as possible. The attorneys at Sivinski Law Offices provide personalized representation, valued for their experience and respected for their skills. If you find yourself in need of an attorney, empower yourself by contacting Sivinski Law Offices for a free telephone consultation at 800-641-1970.